This is our last video for this last minute lecture. We'll talk about our topic 10 and 11, which we'll discuss crimes against property and crimes against public interest. When we say crimes against property, we talk about things, no? And when we talk about interest, public interest, we talk about forgeries, falsifications. But let's concentrate here first. When we talk about crimes against property, we talk about things and the taking of those things or the destroying of those things. Now, if we take something, personal property, with force, violence, intimidation, that becomes robbery. If we use force, intimidation for a person to execute a deed, that will fall under robbery. Execute a deed. Now, without force, violence, intimidation, that will be theft. If there's an abuse of confidence, that's qualified theft. And there's a provision if chattel mortgage is taken out of the place where the chattel mortgage was made. That's in Article 319. What's the point? The point is all of these are things, personal properties, movable properties. Now, in 308, be careful, there is this other thefts. Now, if you found lost property and you do not return that, if you maliciously damage a property, you remove the thing, all right, you use it, or this one, if you enter a enclosed field where trespass is forbidden without permission to hunt, fish, gather, and be careful of this because you might think this is trespass to something, right? But when you enter an enclosed field where trespass is forbidden without permission and your purpose is to hunt, fish, and gather, that is another kind of theft. Now, when we talk about force, violence, intimidation, that's robbery. But if there are four people who agree to robbery in the highway, so that's a very specific purpose, robbery in the highway, or kidnapping of persons for a purpose of extorting ransom, that will become brigandage. Now, if you help brigands do their work, you tell them the movement of the police, you help them. That is aiding and abetting a band of brigands. A while ago, we talked about theft as something that talks about personal property. There's usurpation, where a possession of real property, if you usurp real rights, or if you reserve landmarks there. So there's usurpation. Now, a while ago when we talk about things or property, there's this taking and destroying. Now, taking, we've been seeing the taking without force, violence, threat, and intimidation, with force. And this one is another kind of taking, swindling. It's as if you take a property, but take note, it's a swindling, and it's by a deceitful act. But we won't discuss that now. We will discuss that later together with this one, the falsification. We'll discuss it together there, with swindling and falsification. So we move to one more thing that's left for taking of crimes against property is the destroying. If you destroy it by fire, arson. If you burn your own property to commit a crime, or you burn your property to defraud somebody, that's arson. And the other way of destroying things, not by fire, that is your malicious mischief. All right, so let's go to this. When you talk about public interest, we talk about fake things. Okay, be careful with the words. There's this word called falsified and forged. Those are different things. There are other falsities and frauds. All right, so we start with this one, forged. Take note, when you talk about forgery, it's difficult. It's different from falsification. Look at Article 169 now. How is it committed? It's committed by giving the appearance of something genuine. All right, you give something an appearance of it being genuine, even if it's not. That's your forgery. You alter, you substitute a figure contained in that document. But Well, what on what on what on what? Where do you do that appearance of being genuine? You do it on treasury, banknotes, obligations, securities, other documents or instrument payable or not payable to bearer. All right. So when you talk about forgery, we're in this context now. When you make it appear that that thing is genuine, or when you substitute figures on that thing. So what are those things? Treasury, banknotes, money, obligations, securities, and there's also forging the seal of the government of the Philippines and forging coins, or you mutilate coins to get the precious metals from the coins. Those fall under the topic of forgery. All right. Now, when you talk about other falsities, you're talking about a usurpation of authority. You usurp an official function, or the illegal use of a uniform or insignia. Those are the things that fall under the classification of falsities. Now, other false things are when you make a false testimony. The Revised Penal Code says it is punishable if you make false testimonies in a criminal case, 183, 180 to 182, in a civil case, and there comes perjury. So what is perjury? If you look at perjury in 184 of the Revised Penal Code, it says, this is how the code defines it. It is a false testimony which is not in a criminal case, not in a civil case. There's an affidavit which which was swore under oath in front of a person who has authority to take oaths. So that is your perjury. Now, when we talk about frauds, there's frauds in public auctions, monopolies. That there's a special law now on competition, trademarks. There's a special law now on, so we will not discuss that. And trading of gold. So those are your frauds. All right. So, like I said, we will talk about swindling in the context of falsification. All right. We'll talk about. All right. Take note. This will be the bottom line because the discussion may become quite boring and long, but I want you to know that the bottom line of this discussion is this. Take note that defrauding per se, when you defraud someone nanloko without any fake document, that is swindling. Now, if you look at Article 171, when you talk about falsification, you do certain acts. We'll discuss that later, on a public, official, or commercial document. That's it. There's a second form of falsification when you do acts of Article 1, when you do acts under Article 171 on private documents. You will have to prove damage, or you will have to prove that there was an intent to defraud. Now, this is where things become tricky. What if the defrauding or the estafa was done using a falsified document? No, this is the decision of the court in Co versus People. This is how it works. They say the Supreme Court decision says if there was a defrauding using a falsified document, which happens to be a public document, official document, or a commercial document, that will become a complex crime under Article 48. All right, I'll explain more in a bit. But if there is a defrauding using a falsified document, which is a private document, the crime is falsification. All right, I'll explain later, but that is the bottom line. All right, let's go to this one. Now, let's discuss swindling and other deceits and falsification. Now, when you talk about falsification, you look at Article 171. It says a public official, just look at the enumeration, will have to do these acts, any of these acts, for it to become falsification. You counterfeit the handwriting or signature, public official. You cause to appear in a proceeding. For example, there's a wedding ceremony. The person really did not appear. And you're a public officer. You cause that person to appear. Or you make that person say to make statements. Sabi niya kunwari, I do, but that's not true. That is a falsification by a public official. Now, if there is an untruthful statement in a narration of facts, take note, merong false testimony, which we discussed a while ago. It kind of overlaps, false testimony and perjury, we discussed a while ago. This one is a public official making this statement in a narration of facts. Alright, this one is false testimony. This happens in court. Perjury, not in a criminal case, not in a civil case. An affidavit of a sworn affirmation. When the public official changes the date, or when a document is altered to change its meaning, or when you say there's an authenticated copy but there's really no original document. Say for example, you're a registrar of deeds and you said na this is a certified true copy of a document but wala talagang original document. Falsification. And if you intercalate your registry book. Now, if a private person does these acts, any of these acts, in a public, official, or letter of exchange or commercial document, that is your falsification in a private by a private individual. If that private individual makes all these, does any of these 8, but in a private document, you will have to prove damage or intent to cause damage for it to become falsification. Now, there's 174 to 176 when there are false medical certificates, merits of service, and if you are in possession of tools for falsification. Take note, and this will be important when we talk about the bottom line later. Notice that when you talk about falsification, there is a document that is a general rule. But when you talk about swindling or estafa, the general rule is that there is a defraudation, panloloko. And documents were only mentioned. Of course, there can be panloloko or defrauding using documents, but despite all that long enumeration, the word or the idea of document appears only in, when there's already a signature in blank, bouncing check, fictitious contracts, which are under other forms of swindling. Take note, I just want to go through this. What's the difference between the bouncing check and BP22? If the check was the reason for you to part with the money, that will become estafa. Say for example, I tell you, can you deliver to my warehouse? What? 1 sack of rice. Okay, sure, but I need to get paid. Oh, but sure, here's your check. If you say, okay, sige, I'll deliver the check, I'll deliver the sack of rice to your house because of that check, that is your swindling or estafa using bounce check. If the check was the reason to part with the money or the thing, or if the fraud was simultaneous to the taking of that money. All right, so like we discussed already, swindling, other deceits, we talk about defrauding someone else. How do you defraud? Well, take note, the documents are not mentioned many times here. The defrauding is when you say, for example, I'll deliver to you 1 sack of rice. Ibang rice yung dinala mo. If similar to this substance, when you receive something like equipment but you do not return, the abuse of confidence, and this one, signature in blank. If there was already a signature given to you in blank and you defraud using that signature given to you in blank, that is your abuse. That is your swindling via abuse of confidence. Now, there's another swindling called through false pretense. When you show your fictitious name, take note, there has to be a defraudation. So if you say my name is, you say a different name. Say for example, I'm Mark, but I'm really Jose. There has to be a defrauding. If the false pretense is something about business, if you pretend to have bribed a government official, this is where your post-dated check comes in. It has to be simultaneous to the fraud, the one I was talking about here. And where's this one, surreptitiously leaving the hotel without paying with the intent to defraud. Now there's a third type where the fraudulent means when you use fraud for that person to sign a document, or when you use fraud to ensure success in gambling, or when you remove records or documents. Other forms of swindling, well, you pretend to be an owner of the real property and you sell it. When you dispose or encumber when you dispose a property which is already encumbered, even if it's not recorded. So, as a general rule, if a property is encumbered but it's not recorded, it's binding between parties. That's your civil law discussion. But if you dispose that encumbered property, even if not recorded, that is another form of estafa. If you take personal property from a lawful possessor, if you receive compensation, even if there was no labor, that is another form of estafa. Or selling of surety without court authority. And there's the swindling of a minor, or taking advantage or credulity of other persons. Well, that's where fortune tellers are mentioned, 318. All right, so let's talk about this one. There. So what makes it what makes this very confusing is that swindling talks about deceit. Falsification, parang naloko ka rin. All right. So what's the difference? When you talk about defrauding per se, and this is what we discussed already previously, if it's a fake document, if you do not use a fake document, as a general rule, that will most likely be a swindling or estafa. If you do the acts mentioned in Article 171, if you're if you're a private person, you do Acts 171 on a public official commercial document, that is a falsification. And if you're a private person, you have to prove the damage or the intent to defraud. All right. Now, like I said, defraud. What makes things complicated is if the defrauding was done using a falsified document. This when defrauding is done using a public official commercial document, that is a complex crime because this in itself, if you commit acts Article 171 on a public official commercial document, you do not need fraud. You do not need to show damage. That per se is a crime. All right, and if you use that, so this is one crime. You commit this. You do acts of 171 on a public official commercial document. That in itself is a crime. And then you use that to defraud another. According to jurisprudence, that is a complex crime. Now, if it is a private document and you use that public document to commit fraud, the crime is falsification, according to jurisprudence. Why is that so? Because if you look, it says there, in a private document that causes damage. So that is your jurisprudence on the intersection between falsification and swindling or estafa.